Sharael, Taha. Thank you.
Thank you, Mr. Speaker, sir. The amendments will enable legal proceedings to be more accessible to everyone by simplifying the language used in courts and support our overall digital transformation plans, keeping our legal system efficient and ready to meet the evolving needs of society in the future. I'm in support of these amendments. However, I would like to raise 3 clarifications. Firstly, simplification of words used in courts must not compromise on common understanding of terms. Secondly, there are potential implications of simpler language and accessibility of legal system. And finally, clarity on when remote hearings should be considered. Firstly, while it is laudable that we want legal proceedings to be more accessible to the public, we must ensure that words, especially new words used, should be properly defined. There should be a clear definition of terms such that all those involved in the proceedings are clear of the meanings, such that it is not open to different interpretation, and subsequently become a point of contention in the proceedings. An illustration is the use of the word claimant instead of plaintiff. The word claimant is used in many contexts, such as claimant in insurance claims, or in the US, claimant for welfare or tax benefits. Plaintiff is more widely used in the courts. It may be the case where it is not just possible to simplify legal terminologies, and to change for the sake of accessibility may prove to be detrimental to due process of the law. Secondly, with easier access to courts and better understanding of legal terms and proceedings, laypersons may seek to defend themselves in court. Unless the person is well read in Singapore laws and familiar with due legal processes, the desire to defend oneself in court may ultimately prove detrimental. In the recent case of the individual publicly known as the MBS badge lady, the defendant's initial attempt to represent herself in court met with various challenges. Subsequently, her family had to step in, engaging a lawyer to finally represent her in court. While we want our legal system to be more accessible, we should also be careful not to develop the mindset of engaging legal representation only after attempts at self-representation had resulted in getting themselves into a deeper legal predicament. Another cause of concern is the public misunderstanding of our legal system. This is in light of our exposure to the American legal system and lately, even the Korean legal system from popular media. Obviously, there are differences between our legal systems. However, members of public sometimes misunderstand that and expect our legal proceedings to be similar. The Miranda warning, for example, is used in the American system, where a citizen's right to remain silent is read to the person being arrested. However, in our legal system, remaining silent could draw adverse inferences. Importantly, our changes should be recognized internationally, as we are well accepted as a leading global dispute resolution hub. We cannot afford to make changes at the expense of the rest of the world's legal fraternity not understanding us. We must avoid changes that make our legal system overly localized, as we are too small a country to change the norms and nomenclature of the international legal fraternity. Lastly, while we understand the need to have remote court hearings and sentencing during the pandemic, we must be very clear during normal circumstances as to when we could allow remote hearings. We cannot discount the fact that in some cases, it is important for the judge to be able to physically see the plaintiff or defendant and even witnesses, as it allows the judge to assess their demeanor and to see if the person is being prompted to respond. All this may have an impact on the eventual sentencing and hence should not be taken lightly. Hence, we must be very clear as to when we can utilize remote court hearings and not compromise the legal process for the sake of conveniences afforded by the use of technology. We must also be mindful to not be perceived as being too cold or inhuman when employing remote hearings. As an example, the remote sentencing of Punithan Ganesan, where he was handed the death penalty via Zoom in May 2020, was understandable at the height of COVID-19 pandemic. However, in normal circumstances, it may seem very detached and procedural for capital punishments to be meted out via Zoom. Mr. Speaker, sir, in summary, the amendments will enable legal proceedings to be more accessible to everyone by simplifying the language used in courts and also support our overall digital transformation plans, keeping our legal system efficient and ready to meet the evolving needs of society in the future. Notwithstanding the clarifications above, sir, I support the bill.